Okay, so I just want to welcome everyone. I am going, give me one moment. I'm going to go ahead and pull up a PowerPoint here and then we'll get started. So we are going to be talking today about the topic of discharging student loans in bankruptcy. And I want to give my sincere thanks to our volunteer attorney, Frank Turney, who does quite a bit of volunteer bankruptcy work with MVLS, who has offered to donate his time to share with us about this topic today. And I want to thank everybody else who was able to join us on this training. And I will talk for a couple of minutes about MVLS and why we're doing a training on this topic and how you can get involved with us. And then I will go ahead and turn the presentation over to Frank, who will get into the substance of what we're going to talk about today. Just a couple pieces of housekeeping. One is that you can put your questions in the chat at any time. I'll be monitoring the chat. And so I will let Frank know if any questions come in. Also, I have posted in the chat some materials for today's session. Those will also be shared via the via our website, along with a video of the training. So this training is being recorded today. So just to make everyone aware of that. I think those are kind of my housekeeping pieces of information. Do feel free to reach out as we go with your questions. So just kind of a little bit, just some basics about MVLS. If you're a person who does social media, we have our various social media handles, and we will post on there if we're having another training coming up or a volunteer opportunity, or we actually have a fundraiser coming up this Thursday, which is a fun way to be able to network with some of our other attorneys. So follow us on social media and you will find out about all of those great things that we have coming up at MVLS. We also have listed at the bottom of this page our website, mvls.org/mvls-events. And that is where you'll find an event calendar with some of this information about what's coming up as well. So following us is a great way to find out about these things. I just wanted to point out really quickly, and I will come back to this just as a refresh at the end of the presentation as well, but this is what our website looks like. And there's a little arrow pointing to the volunteer tab. The volunteer tab is where you would go if you were interested in taking a case from us or signing up to be a volunteer. So if you click on that volunteer tab, you will find something that allows you to apply to be a volunteer. You'll fill out a little bit of information about yourself, what types of cases you might be interested in taking, and what areas you're interested in volunteering in. And then we will contact you with some welcome information and to answer any questions that you might have. And if you want to volunteer with us, but maybe you don't have much experience at all in some of the areas that we work in, we do have training such as this available for every area we place cases in with our volunteers. And we also have mentors available. So we certainly would be able to connect you with a mentor, whether that be one of our staff attorneys or a volunteer like Frank, who would be happy to answer any questions you have as you're working through your MVLS case. I'm going to show, I'll save this for the end of the training, but I am going to also show you our pro bono portal, which is how you can, we actually have a section again in this volunteer tab of our website where you can see a little blurb on every case we currently have available, and you can pick what case might speak to you. So it's very easy via our website to see what we have out there and what you might be interested in. I am just going to talk really quickly about MVLS's bankruptcy clients. Why does MVLS handle Chapter 7 bankruptcies? Why is this important? Just kind of frame why we are putting on this presentation today. So we have collected some data on our debt collection clients that we see through our consumer protection clinic. Many, not all, but some of these clients do end up going on to file bankruptcy. So who are the clients that we see in our consumer protection clinic. Kind of from our data over almost 10 years now, the average client, I guess if you want to say, is a Black woman earning less than half of the Maryland median income, typically in her early 40s, more often than not caring for at least one child or one parent at home. Most of these individuals do not have a college degree, although some of them do have college debt because they have gone to school and so paid for part of college, but don't have a college degree. Some do, but that's part of what we're going to be talking about in our presentation today. And then we also, for MVLS cases, at least the Chapter 7 cases that MVLS has, the clients don't typically own a home or have any major assets. So we are typically working with individuals who are renters, and they are kind of getting by paycheck to paycheck typically. With that, this is what the pro bono portal that I was mentioning looks like, but I'm going to come back to this at the end of the presentation. So I'm going to stop my screen share, and I am going to turn the presentation over to Frank to speak to us about this issue of discharging student loans in bankruptcy. So Frank, I'll turn it over to you. Thank you.
Thank you. Hello, everyone. So we're here today to discuss student loan discharges in bankruptcy. My name is Frank Turney. I've been practicing I'm in my 30th year. I've been doing bankruptcy since the beginning. I've been a solo practitioner for 30 years and have been involved with Maryland Volunteer Lawyers Service for probably 20 plus years at this point. I can't get away from them. No, they're a fantastic organization, and I apologize for the noise from my phone since my secretary's at lunch at the moment. So we're going to dive right into this real quick. So most of the cases, like Margaret said, were, at MVLS or Chapter 7 cases, so we're kind of focusing on Chapter 7s. There's kind of a misunderstanding out there about student loans and bankruptcies. A lot of people tell you can't discharge a student loan in bankruptcy. Well, that is not correct. The statute does give us the ability to discharge student loans in bankruptcy. The problem is that the bar is set extremely high, which this is going to be a little bit changed under the current Department of Justice guidance. But if we look at we're in the Fourth Circuit, the federal Fourth Circuit. So generally in the United States, there is, let's before we get into that, section 523A8 is the exception to discharge, which basically indicates unless accepting such discharge, the debt from discharge would impose an undue hardship on the debtor and the debtor's dependents for the student loans, it can't be discharged. So the courts have looked at what's this, what qualifies as an undue hardship to the debtor or the debtor's dependents. In the United States, the courts have come down with two different tests. One's called the Bruner test, BRUNNER, which we use here in the Fourth Circuit, and then the other one's called the totality of the circumstances, which is used in some of the other jurisdictions. The Bruner test, which is, it's kind of a three-pronged test. It is a three-pronged test. The Bruner test basically says that if you look at the debtor's situation, that the debtor cannot maintain a minimal standard of living if he's required to pay the student loan. It also looks at that the circumstances exist that the current state of that being unable to maintain a minimal standard of living will persist for a significant portion of the loan repayment period. And then finally, the debtor had made some good faith efforts in the past to repay the student loan. This has been a difficult standard to meet. I myself have been successful once in getting that met in Maryland. It's, I believe, a 2010 case. I attribute it to the fact that I had kind of the perfect client for this type of case. My client was in her 60s. My client had a mental disability. My client hadn't worked really for 30 years, and there was no hope that she was going to be able to work in the future. And at the time, she was only getting Social Security disability. And so the income and expenses were clearly that if she had to pay, and unfortunately, the amount of the debt was large. I think it was $300,000 plus. So she met the standards. The standard that was the problem was number 3, which was the good faith efforts to repay the loan. There is case law in the Fourth Circuit that says if the debtor hasn't made some payments or the debtor hasn't availed themselves of the programs that the lenders have available, like income contingent repayment plan, some of these other programs that they have, that is a sign of not having the good faith effort to repay, which would kind of kill you in the tracks if you met the first 2. In my case, the court concluded that my client, partly because of her mental disability and her sort of ability, well, she had this paranoia about the federal government. She had paranoia about the student loan servicers, that she couldn't avail herself of these types of programs. So the court found that she did have a good faith effort because she had made some payments way in the past. And, you know, the court did rule in our favor, and we did get a discharge on that. I don't know if that case would have been upheld on the appellate level because of the lack of her availing herself of the programs. But fortunately, I think the DOJ, and there was some private lenders involved as well, made the rational decision that it didn't make sense to push this case since they were never going to get any money out of the client. But and if you looked at most of the cases in the United States after that, where courts were granting discharges, almost all of them involved some sort of physical or mental issue. There was a medical reason that the person couldn't work. A lot of these other cases where they didn't have that, they weren't being successful. So, and sort of a step back for sort of procedural thing, because I'm going to assume that, you know, people are listening to this may
Frank,
not.
Can I jump before you step
Sure.
on to the next issue? The first part of the test, the minimal standard of living, you mentioned your client was on Social Security, but what are they looking for? I mean, when I think about, for instance, MVLS clients, you know, you may argue that most of them have a minimal standard of living.
Correct. That's a great question. And if once we get into the new guidance, I'll get into that in depth and sort of point that out to you. So for those who are just sort of getting into this sort of area, and I apologize if I'm just, you know, saying stuff people already know, but if you file a Chapter 7 case, you have the case in chief. So that's the regular bankruptcy case. You're going to file your schedules, your petition, all the documentation. There's going to be a 341 meeting of creditors where your client's going to be questioned by the trustee, and they got to do what they need to do, and you're looking to get the discharge. In order to get the student loan discharge, you actually have to file an adversary case within that case in chief. So what does that mean? It basically means that you're filing a lawsuit or a complaint against the student loan providers to determine the dischargeability of the loan. So it's almost like a lawsuit it is a lawsuit within the bankruptcy case itself. And it's litigated like, any other type of, contested case. You file the suit, summons are issued, you serve the summons on the defendants, they have a time to answer. Discovery is available on both sides. In the case that I did, we had depositions of doctors, we had depositions of my client. So there's interrogatories, there's the whole 9 yards. So it could be a serious undertaking to, proceed on an adversarial case of this thing. This is why this new guidance, though, has sort of changed the parameters of this and kind of made it worthwhile in cases that are applicable. So what do I mean by that? So under the Biden administration, Department of Justice came out in November with the guidance for bankruptcy attorneys regarding student loan bankruptcy litigation. That is in the comments. This is kind of like the step-by-step analysis of what the DOJ attorneys are going to be looking for in terms to the ideal situation we're looking to get to is where the Department of Justice attorneys who are representing the Department of Education will stipulate that you have met those parameters and a discharge is warranted. And we're going to get into the details of what you need to do to try to get to that goal, because it is it's easier. I don't want to say it's necessarily easier, but it definitely is making it more possible with the new guidance. Now, let me be clear. The Department of Justice only deals with federal loans. If you have private loans, none of this makes sense. There is no necessarily a private, the private side hasn't jumped on this. Now, that doesn't mean that potentially in cases where you have a mix, where you have federal loans and private loans, that potentially if the federal loan is going to be dischargeable, it still makes sense to do it. The other thing is like in the case that I had, some of the private student loan servicers and lenders, they agreed that if I was successful against the DOJ, they would also allow the discharge as to theirs, which made sense because if I was able to win under the standard under the DOJ, the privates would also get the discharge as well. So, but you get into this is a little different because the DOJ attorneys could be stipulating, but they're only stipulating as to themselves. They're not necessarily, a lender attorney could say, no, I don't think you're going to win this and force you, to go the distance on the litigation and make a judge make that ruling. So it's easy. It's an easy decision if it's just federal loans and it's, and you're going to, file the case on the federal loans. It's easy. I think it's also an easy one if you got somebody who's got a federal loan that's 97% of what they owe, and they got a tiny, private loan. That might even be a situation where you file just against the DOJ, and the client may end up having to pay back that smaller loan so that you don't get into it, or you reach out to the private lender and see if they're willing to agree that if you're successful with the DOJ and the Department of Education, they'll go along with that as well. I think it's, if the amount in controversy or the amount that you owe on the private loans is not significant, I'm not so sure the private lenders are going to sit there and spend a lot of money to defend that. where they might just say, okay, if you can convince the Department of Justice this should discharge, then I'll go along with that as well. So that's something more of a pragmatic sort of thing. So back in November, they issued this guidance for all the attorneys to look at. It basically is still sort of following along with the Bruner analysis, but it gives us more information on how, if we have certain certain parameters, that it's going to satisfy the DOJ lawyers. And as one of the question that Margaret came up with was, how do we determine the minimal standard of living? The DOJ's guidance is we're using the IRS, basically collection tables, and they're easily found if you just go on to you search for IRS. It's the IRS. There's two of them. There's IRS for national standards, and then there's IRS for local standards. They have different ones. And what they do is they update them each year, so that you can pull up these charts, and these charts will give you the information in terms of, what housing for a family of 3 is going to, be pegged at for Baltimore City, Maryland. And then they also use, the national standards, can have other costs, because they have 2 different standards. National standards are, they're basically for like food, clothing, and other items. And then the local standards are more for like utilities, housing, rents, stuff like that. So they do kind of put that down there. Now, the form that you're going to eventually end up using, which is the attestation form that the Department of Justice attorney should send you once you file the case, it has the living expenses and food, housekeeping, apparel, non-medical, medical, those categories broken down already in that attestation form. So that gives you the ability to, sort of see whether your client is over or above that to begin with. So that's one of the first thing you need to sort of look at is the assessment of the debtor's income and expenses. So you're going to take a look when you file the Chapter 7 case. You're doing the Schedule I and J, which is the income and the expenses, and we're also doing the means test. The means test actually uses some of the same numbers from the IRS system, and on the form that you fill out for the DOJ, they do have different. You can use some numbers from Schedule I or J, or some numbers from the means test, depending on what they're asking for. But basically the first thing we're looking at is we're looking at the income and expenses to see if the debtor is maintaining that minimal standard of living based on the family size. One of the things you have to keep in mind, just like the means test and Schedule I, is it's based on the household income. It's gross household income. So if the debtor is married, or the debtor has adult children that are potentially, or even minor children that are working part-time, that income needs to be included in the gross income. And then you're going to take look at the expenses. And then obviously if the expenses are at or below the national or the local standards of the IRS, and then you subtract that from the gross income, and it's 0 or less, on its face, they immediately have satisfied the ability that they can't maintain a minimal standard of living based on that. So that's, that's kind of the, now there's going to be instances where there's expenses that don't fit the mold. An example would be is if, let's say they have a family member who has a medical disability and there's additional expenses to the household that, other people don't generally have. That you can, put that in there. You can do that. Just because it's because the local and the national and the local aren't going to catch every expense that is justifiable. So you definitely want to talk to the debtors and make sure you're getting all the expenses that make sense. Here's the other thing that's sort of a pragmatic thing. A lot of times you're going to have clients who their housing costs are going to be artificially low because they're living with mom or dad, or they're living with a family member temporarily. You have to factor that in. So it's not, in my opinion, it's not, I don't think it's unreasonable to use what the local standard for a housing cost would be as the expense, because that's what they should be paying and will be paying as soon as they can, get out of their current, financial distress. So that's kind of what we're doing in terms of, now, just because you have, you do the gross income minus the expenses and you come up with, a positive, it doesn't mean that you've been shot out of the water. You have to compare that positive to what the student loan payment would be. I mean, if the positive is small and the student loan payments are going to be big, it's going to be an issue. So that doesn't necessarily mean the guidance says that you wouldn't be entitled to the discharge. The other thing is that if the sort of the amount of money available to pay towards the loan is not enough for the full loan payment, there's the option for a partial discharge that the Department of Justice may be willing to entertain, so that you may not get the entire amount discharged, but you may get a significant portion discharged. And it almost goes back to sort of the income contingent repayment plans system. If the family is making this amount of money and this is what's available to pay towards this loan, okay, let them make that payment towards the loan for a certain period of time, and then let the balance of it discharge, or the balance would be forgiven in an income contingent repayment plan. So in this situation, it's kind of the same sort of philosophy. So they're willing to allow the debtor to make these payments and then give them a partial discharge. The other thing is, this shouldn't be an issue in terms of income side, but generally if you filed the Chapter 7, you can use the Schedule I as the, your income numbers. If it's beyond 18 months from when you filed Schedule I, then you would have to, update them, but generally that shouldn't be the case. Let's see. Now, so let's say we've gone through this whole thing. We've crunched the numbers. The client clearly does not have the income to maintain the minimal standard of living for him and his family or his dependents. Satisfied number one. So now we have to look at number two, which is this inability to repay, is it going to persist for a significant period of time going forward? So there's several factors that play into this under the guidance. And it includes being 65 or older. It includes having a disability or a chronic injury that's affecting your ability to make income. if you haven't been employed for the last 5 or the last 10 years, if the debtor failed to obtain the degree for which the loan was procured, or the loan has been in payment status other than in school for the last 10 years. Okay. Now, here's the thing. It's not like one of these is the magic, circumstance. Obviously, the more of these circumstances you have, I think it's more indicative that there's no ability for you to repay this loan, which is going to strengthen the case. Because remember, what we're trying to do here is we are trying to convince an attorney at the Department of Justice that you should be entitled to a discharge on this. So the more sort of evidence we have concerning your inability to repay this loan, or let me put it a better way, the more evidence that your current financial situation is not going to improve, then I think that is strong evidence that that part of the analysis has been met, that the financial situation is going to persist in the future, and that would be checked off. One of the things, while it's kicking in my brain, remember, at the end of the day, the Department of Justice does not have the power to discharge the case. Who has that power? That would be the bankruptcy judge. So even with all this said, at the end of the day, it's still going to take the judge to agree, with everybody. So assuming the Department of Justice stipulates that the debtor has met the standards, there is a risk a judge could disagree. In this, in the Maryland bankruptcy court, my suspicion is I don't see most of these judges disagreeing with the assessment if both parties have done what they're supposed to do, and the DOJ stipulates that yes, this does qualify for discharge. I would be kind of shocked if our current crop of judges would have an issue with that. But we do have to throw that out to you and make sure that that it's not, it's going to end up being the court to make this decision. But when you make things easy for the court, they tend to, I think, plus I think it's not like an analysis hasn't been done, and clearly the analysis could be presented to the court for doing this if the court wanted it. All right, so let's say we've checked one and checked two in terms of the test. So we've shown that they can't maintain their minimal standard of living with their income and expenses. We've also satisfied that it seems like this is going to persist for the majority of the repayment time period for the loan and going into the future. So now we have to show good faith. This is where most cases could potentially fail, because if you had a strong case and satisfied 1 and 2, the good faith thing was a problem. In my case, I was concerned that if there was an appeal, I would not win because of the lack of the client to try to avail themselves of the programs that DOJ had in place. This is kind of addressed in this guidance, because a lack of trying to avail yourself of some of these programs is not evidence of lack of good faith. And the reasoning is actually, I think, pretty good. One of the reasons is that a lot of times debtors are getting wrong information. They get information from certain places that, is not accurate. And that, that sometimes screws them up on trying to do what they should be doing in terms of trying to use some of these programs. Now, certain things are clearly evidence of good faith. Obviously, if you've been making payments, that's good. If you've applied for a forbearance or deferment, usually not because you're in school or a grace period, but for some other reason, that's I think evidence of good faith, and the guidance says that. If you've applied for the sort of the income plan with them, that is, or you try to do a federal consolidation loan, or you have been engaged with the servicer or the collector, that all shows that you've tried, you haven't ignored it. You've actually, you've taken steps to try to do this. Now, one of the things that happens when you file these cases is the Department of Justice is going to get a statement from the Department of Education that shows the loan amounts, the payments you've made, and the other things that you've done, and contact that you've had with the Department of Education, which goes to, it goes to show how much money's owed, but it also goes to show, help potentially on showing the good faith. What's the other thing? The case law has denied these types of discharges because of lack of good faith. A lot of that has been addressed in the guidance. Like I already said, that if you're not enrolled in one of the programs with them, that is not a automatic assessment that you lack good faith, which is a big step, because a lot of the debtors would not necessarily use the program for one reason or the other. So that is very helpful in terms of that. So I think from a practical standpoint, when we have a client walk in the door, wants to do a Chapter 7, I think we need to go through this, and they have student loans, and they have student, let's say it's right now it's just federal student loans. I think we need to go through this process and then go through the form that you eventually would have to file with the DOJ to sort of take a look and see where you are in terms of the potential success of getting this loan discharged for the client. Before this change, I think most bankruptcy practitioners would usually tell their clients, look, the odds of getting this discharge were remote at best. And the cost to litigate these things when it's not pro bono can be sizable. But now with this change, I think, honestly, without, I think most bankruptcy practitioners, when you have a Chapter 7 come in and you see there's a student loan, they need to look at this, very well, just to advise the client to see if it's worth pursuing. In some cases, it's not going to be. The income is just too much, or the expenses, or they have enough money to pay the loan back. It's just not going to work. And there's cases that aren't going to work. They're not going to work. But there's a lot of cases, especially coming out of MVLS, that I think will work. And it's going to make sense to do that. The last sort of thing we got to look at, though, and so assuming we've checked off 1, 2, and 3, the minimal standard of living can't be met, it's going to persist in the future, and they've made good faith efforts. We have to look at assets. Okay. Now, MVLS cases, basically 100% of the time, they're not going to have real estate. So we don't have that kind of issue. But even if you have a case with real estate, that doesn't necessarily mean that you're at, you're, let's put it this way, real estate with equity in the house. The guidance is real clear that we're not expecting people to sell their residential home to pay off a student loan. The other asset that is, again, I don't think we're going to have that much issue in MVLS cases, but in normal case, other cases would be retirement savings. If you have a sizable retirement savings, again, that is not an obstacle for the Department of Justice to conclude that you're entitled or you should be recommended for a discharge, which is huge, because when you could have a family who's sitting in a house and they may not even have a mortgage on it. It could be worth $300,000, but that's where they live. Prior to that, it would be difficult to justify, them getting a student loan discharge if they were sitting on sizable assets. Now, this guidance clearly protects residential real estate and it protects retirement savings, which is it's a good thing to have. So, so that's kind of the last thing that the Department of Justice attorneys are going to be looking at. Now, so what's going to happen? So we get a case, we file the Chapter 7, we look at it, we get the form out there, we start crunching all the numbers, filling out this form, which is was 14 pages long. So it's not a small form, but and it makes sense. So you decide, you go ahead, you file the adversary. Now I have two examples of adversarial complaints that I have in the comments that I uploaded to MVLS that you can look at. They both have Mickey Mouse as the debtor. I changed the names to protect the innocent. So that's something that you can use as a form to sort of give you an idea on what you need to do. Once you do that, you serve the Department of Education, and in a perfect world, it gets kicked to the Department of Justice, and then the attorney at the Department of Justice is going to send you the attestation form to fill out for him, and they're also going to request the Department of Education's records on that debtor in terms of the student loans, which is also, and they should send you a copy of that as well, so you can review that. And you want to take a look at that with your client to make sure that everything sort of makes sense. So, once that's done, now here's where we kind of get into one of these situations on what do you do when it's a case that may or may not get through. You filed the adversary, you now are stuck in the situation. Those cases, and actually in every case, you definitely want to have the conversation with the client, because I'm not a big proponent of tilting at windmills. So if you have a case that clearly is not going to work, it's not going to work. I think that's an easy conversation with your client to say, hey, this is not going to work for you. If it's a case that's close, you have to have that discussion with your client and say, look, we can give it a shot, but if we can't get the stipulation out of the DOJ, then there's a decision to be made. Are you going to continue down the road with the litigation, or do you decide, it's not going to work, and then you got to, do a voluntary dismissal at that point? That's a conversation I would strongly recommend you have with the client before you even start anything. That's why when you first get the Chapter 7 cases and they have federal loans, we should be looking at this ahead of time to see where we are. Because, clearly if it's, it's a lot of work to do an adversary case that's contested. You're basically litigating a case. And with the Bruner standard and the current case law, without the stipulation from the DOJ, it can be quite difficult to get to discharges. Some people would say some cases impossible. I don't think it's impossible, but it is hard. So that's something I think you need to be cognizant of, so that if for some reason the DOJ doesn't give you that stipulation, you got to have that conversation with your client on, do you keep pressing forward, or do you cut your losses and move on? Now, here's the thing. Most cases, if you're doing a Chapter 7, they have student loan, but a lot of times they're going to have other debt. And even in the cases where you may not be able to get rid of the student loan, you can help them by getting rid of the other debt. So if they still have to, now and the other thing is if you get rid of the other debt, that gives them, hopefully loosens up some room to start servicing the student loan. Or the other thing is they can also start looking into the programs that the Department of Education has to try to resolve some of this. So it's not the end of the world, just because you can't get the student loan discharge. But I would say that you're going to have that hard conversation with the client. If you file the adversary, you don't get the stipulation from the DOJ. What are you going to do? And that's
right. I have a question that's going to
sure.
Point me out as not a seasoned bankruptcy practitioner probably, but I'm thinking about timing. I'm sure this is actually probably true for all bankruptcy clients, not just MVLS. A lot of times people come to you about filing a bankruptcy because there's something time sensitive going on, right? So I'm just thinking, if you file this adversary case in their bankruptcy, does that push back the meeting of creditors getting scheduled, or how does that work?
No, so it doesn't really affect the timeline for the case in chief. Okay, that'll go forward. Your 341s will be handled like they usually are, and things will just keep going as they usually are. And then it's kind of like this adversarial case is sort of a separate, it's a separate animal, and it's going forward on its own timetable as well.
So I imagine it could probably take some time, given that you're dealing with the Department of Education and the Department of Justice.
I think right now they are trying to make things go quicker, but obviously I think with this becoming, they could be inundated with these types of cases just because of the new guidance. I don't know if that's going to end up being an issue or not in terms of them, but yes, it could drag out. I think my case was an anomaly, but when I did it before this, it was almost 3 years before we got the final decision.
I imagine. So, but what you're saying, I think now, is that the person might get the discharge of their other debts while this question about the student loans is ongoing.
I believe that is accurate. Yes.
Okay.
So because the question is it's going to boil down to, did that discharge include or not include this debt? So it's not a question of whether the discharge should be granted. They do get the general discharge. It's just a question on, is this included or not?
Okay.
So, but it could drag out for a little bit of a while, depending on, I think, a lot of different things. And probably one of the things is just how busy the Department of Justice people are going to be with dealing with these cases. All right. So what's the last thing before, if we have any more questions? I mean, here, I know what I want to tell you. So let's we got to be realistic about what's going on. The reason we're at where we are right now is because we have the current administration in place. That could change. In the next election, And if it does, they could obviously stop doing this. That it doesn't necessarily mean that the current administration could change its decision, and so it's I mean the original guidance was issued in November. The attestation form that I sent out to you guys was just released in March last month. So this is all kind of brand new for everybody. So it's and we're going to have to see how long it lasts and see how effective it is. But at this point, it's hey, yeah, let's use what we have and use it as long as we can. But we're going to have to be cognizant that it could change down the road. There could be a big change, and we get into the whole debate on student loans. I mean, we do have a problem in this country with student loans being a huge anchor on a lot of debtors. And so far, we haven't, come up with a solution that, makes sense. I mean, I have solutions, but not everybody's going to agree with my solutions. But, but I think this is a step in the right direction to try to get some of this, some people who deserve it, some sort of relief from these things. And, we could get into a whole lot of things on how this is going to impact the total economy. We have a lot of younger people who, potentially can't afford to get a house because their loan payments are too high, which at the end of the day causes problems for other things. But so we just have to remember that this is what currently is in place, and let's use it as long as we can for the people we can, and we'll see how it goes. That's it, what I have at the moment, Margaret, unless you got questions on your end.
Yeah, well, first, Frank, I want to thank you so much for being here and for doing this presentation for us. I think let's do this. I will put out an invitation for people to ask some questions if anyone has any last burning thoughts while I am running through just kind of a reminder about MVLS and how to take a case, and we'll see if there's any questions. If not, I just want to thank you again for being on this presentation. So I'm just gonna put my PowerPoint up one more time here. Does that work? Oh, here we go. All right, so this is the pro bono portal. Just wanted to show everyone this real quick. You can sort by the type of case. There is a button here for bankruptcy, and by the county that the individual lives in, which probably doesn't make as much of a difference for bankruptcy, but you'll see, just to kind of give you a sense that these are just some sample blurbs of the types of cases we handle. This is a screenshot from a while ago, so these are not the exact cases you'll see on there right now, but this is what our pro bono portal looks like, and you will just click the button, learn more, and that would send a message to someone on our intake team that you might be interested in that case, and you can ask any questions that you might have of our intake team as you're thinking about your case as well. I did want to mention one other thing that I thought of while we were doing this presentation, which is in case you were here, you don't do a lot of bankruptcy and you're hearing about all the different schedules you would have to file and everything. MVLS does offer free bankruptcy software for our volunteers if that's something that you need access to. So that is something that you would have for your MVLS case, which certainly makes that process a little bit easier. So sorry, trying to go to my next slide here. Upcoming trainings. So one of these trainings is not upcoming, it was last week, but I wanted to show it because it might be of interest to this group as well. We did a training on the affidavit judgment docket and our Consumer Protection Project clinic, which is, of course, another way in which we serve a number of clients who are facing debt collection lawsuits. We have that clinic every Tuesday in the district court in Baltimore City. And we are always looking for volunteers, either in person or virtual, on Tuesday mornings for that clinic, if people are interested in volunteering there. And then I often find that volunteers are kind of aware of like one aspect of what we do because that's the area that you volunteer in. So you might not be aware that we do a lot of different things at MVLS. And actually, I see the word overdose is misspelled on this. So I apologize for that. That's supposed to say overdose prevention sites. So we have a human trafficking prevention program, and they work with victims, survivors of human trafficking. And so this is a training that they're going to be putting on next month, and you know, completely different from this training topic, but something that might be of interest. We assist, actually, a lot of those clients do have consumer related issues that we assist with as well. So those are our upcoming trainings, and you can always go to our events page to see what else is coming up. We have trainings in all of these categories that are listed here on the screen. Basically, any area in which we have cases, we also have trainings. And then finally, how do you sign up to be a volunteer? I leave you with the link to the volunteer sign up page of our website. So I'm going to just go back one more time, and I don't see any additional questions. So Frank, again, I want to thank you so much for being here. Really, really appreciate your time. And thanks for those who were able to attend today.
Thanks for having me. It was a pleasure.
All right. Thank you. Bye-bye.
Take care.